Ready? Start. The trial court had recorded the statement of respondent Ram Gopal under section 10 of the Code of Civil Procedure Stop. The present petition is directed against the order dated 19/11/2009 passed by the learned civil judge on an application filed by the petitioner defendant in the court below under Order 8, Rule 6A, read with Order 7, Rules 10, 10A and 11 CPC seeking rejection, dismissal, return of the plaintiff filed by the respondent stop. By the impugned order, the learned trial court dismissed the aforesaid application of the petitioner and held that the suit filed by the respondent plaintiff against the petitioner for declaring the gift deed dated 29/8/2002 in respect of first floor along with complete roof rights of the premises bearing number 3 Nirankari Colony, Delhi as null and void was maintainable stop. The trial court examined the submissions made on behalf of the petitioner and held that filing of a counterclaim along with the written statement is not obligatory and it is the discretion of the defendant whether to file a counterclaim or institute a separate suit. It was further observed that the respondent was well within her right to have sought a relief of declaration by instituting an independent suit and that the provision of Order 2, Rule 2 CPC had no application because it was the first suit of the said nature filed by the plaintiff in respect of the suit property stop stanza. Counsel for the petitioner submits that the trial court erred in passing the aforesaid order for the reason that the provisions of Order 8, Rules 6A and 9 CPC give a right to a defendant in a suit to file a counterclaim in addition to his right of pleading a set off against the claim of the plaintiff stop. He states that in the present case, the petitioner had instituted a suit in May 2008 for eviction of the respondent herein from the same premises as also for possession thereof apart from seeking a decree of mandatory and perpetual injunction and declaration against the respondent stop. He states that in view of the fact that the aforesaid suit was instituted by the petitioner prior in time to the suit instituted by the respondent on 13/8/2008, the respondent had an opportunity not only to file a written statement in the said suit but also to file a counterclaim against the claim of the petitioner, and having failed to do so, the present suit instituted by her later in time is hit by the provisions of Order 7, Rule 11 (d) CPC, which mandates that the plaint be rejected when the suit appears from the statement in the plaint to be barred by any law stop. In support of the aforesaid submission, counsel for the petitioner relies on a judgment dated 15/9/2008 passed by a single judge of this court in CS (OS) 758 entitled Renu Chavda versus MCD stop. He particularly refers to para 11 of the aforesaid judgment to urge that before instituting the present suit, leave had to be sought by the respondent from the trial court under Order 2, Rule 2 CPC, which she failed to obtain stop. Reliance is also placed on the case Jagmohan Chawla and Annexure versus Dera Radha Swami Satsang and others to highlight the object of the amendment introduced by Rules 6A to 6G of Order 8 of the CPC stop. Order 8 of the CPC deals with the written statement set off and counterclaim stop. An amendment to be said provision was carried out by the Legislature Wide Amendment Act 104 of 1976, whereby Rules 6A to 6G were inserted with effect from 1 to 1977 stop stanza. The petitioner thereupon moved in this court for permission to produce before the court the original agreement bearing the signatures of the petitioner also stopped. The said application was allowed on 21st May 2008 stop. This court directed the respondent to file an affidavit clarifying its stand on the pleading of the petitioner of the agreement having been acted stop. The respondent thereafter filed an additional affidavit under Section 340 of the CRPC. In the additional affidavit, while admitting the transactions with the petitioner, it is stated that the same were on the basis of invoices raised by the petitioner on the respondent and which did not contain an arbitration clause and contain clause regarding jurisdiction of Mumbai stop. The senior counsel for the respondent has urged that though the petitioner did not return the signed agreement but the parties needless proceeded to transact business stop. The application under Section 340 of the CRPC has been filed on the ground that while the stand of the petitioner originally was that the copy of the agreement filed along with the petition was the only copy available with it, the signed copy having already been forwarded to the respondent, the petitioner forged the agreement subsequently filed and bearing the signatures of both the parties stop. The senior counsel for the respondent has argued on the same lines stop, though he had also sought to urge the aspect of limitation but subsequently did not press the same, being a question of trial stop. By the present petition, the petitioner has sought recall of lookout circular and a red corner notice issued by Delhi police and Interpol against the petitioner alleging that LOC and RCN were issued in arbitrary and malified exercise of power by the respondent stop. The petitioner claimed that he was a Canadian citizen since January 2004 and a person of Indian origin stop. He had married one Miss Rima, daughter of Professor R.S. Manan, on 24th March 2002 according to Hindu rites and ceremonies at Infantry Hostel, Delhi Cantonment, New Delhi stop. At the time of his marriage, the petitioner was living and working in Canada and he came to India on 3 weeks leave for the purpose of marriage stop. The marriage was settled with Miss Rima through matrimonial advertisement in newspaper stop. The facts reveal that wife of the petitioner was not able to join the petitioner in Canada as difference arose between the parties in the very beginning stop. The petitioner alleged that he was compelled to withdraw the sponsorship made by him for his wife Rima in view of certain developments stop. A complaint against the petitioner and his parents and married sister was filed at Crime Against Women Cell making various allegations stop. Later on, an FIR was registered on the basis of this complaint stop. The parents and sister of petitioner obtained anticipatory bail from the court stop. Since petitioner was in Canada, he could not be arrested by the police stop. Additional Deputy Commissioner of Police wrote a letter dated 27th May 2003 to Foreigners Regional Registration Office for opening LOC against the petitioner stop. This letter annexed with the petition shows that additional DCP asked FRRO to open an LOC against the petitioner at all India basis because of FIR under section 498A 406 of IPC registered at police station Alipur, Delhi stop. Later, a letter seems to have also been written to Interpol wing of Central Bureau of Investigation on 11th June 2003 for opening and issuance of a red corner notice and service of summons on the petitioner in Canada stop. In response to this letter, CBI wrote a letter to Dr. R.K. Bansal, ACP Subdivisional Narela, New Delhi, and informed ACP that summons had been forwarded to Indian High Commission in Canada. Stop over.